It is Monday. It's April 28th. Can you believe it? Neither can I. It's day 5 of the Karen Read case. Today is a half day for the jury as well, but not for us because the ARCCA experts are on this afternoon doing their voir dire. So here's what I expect today. We're going to do a half day of testimony. We'll see what the Commonwealth brings, and then the jury will be excused for the day at lunchtime, and then we will do the ARCCA voir dire. What does that mean? It means that because the court found a discovery violation on the part of the defense, instead of keeping these witnesses out, the Commonwealth gets to ask them the discovery questions that they might not have had. So the Commonwealth gets to go, hey, when did you start talking to the defense? Hey, are your text messages really gone? Hey, what about this? What about that? They think they're going to do this in a half a day. I think that's adorable. We'll see what happens. So this afternoon, we will get that voir dire outside the presence of the jury.
Yes, it was actually one of the public relations managers at Cellebrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp.
What?
And requested if we could.
One of the Cellebrite public relations managers was doing what? Reading Reddit and was like, hey, yo, we got a problem. We are at the morning recess on day 5 of the Karen Read Retrial, and we still have Ian Whiffin on the stand on direct examination. He works for Cellebrite, the company that provides the software that does the cell phone extractions. He has been talking about Jen McCabe's phone and is now talking about John O'Keefe's phone. As to Jen McCabe's phone, he did a PowerPoint presentation explaining to the jury why it is his opinion that a Google search did not take place at 2:27 a.m. for anything related to how long or how long to die in the cold, but that the time that shows on the Cellebrite report, which they did not show, is from when the tab was populated into the forefront, and that was at 2:27 a.m., with searches relating to Hawk Sports, and that those other Google searches were using the same tab, that those searches did not complete, and that when that program was closed, or at least that's my takeaway, when the program was closed, that after 10 o'clock in the morning is when that all wrote from when the tab activity happened. He had a little bit of a snarky side comment when he said this says tab activity time, and that's me paraphrasing. He goes, you think it would be kind of obvious that that's what it meant, but we've had confusion around this, so we've had to change the way the reports report this because there's been confusion around this. I wrote a blog about it. That I'm not paraphrasing. That is exactly what he said. There was confusion, so I wrote a blog about it. While we're still talking about the Google search, the thing that stopped me in my tracks was when this witness said, oh, our public relations officer told me about this case and that there was confusion regarding this Google search. And then he said, and then I reached out to law enforcement. Brennan asked nothing more about it. We're not in cross yet. And then Brennan said, well, did law enforcement reach out to you? And did someone else reach out to you? And then he answered and talked about the fact that the defense expert, Mr. Green, though the jury, I don't think knows that's the defense expert yet, but Mr. Green reached out and asked about these Google searches. And then he finally got back to Mr. Green. It seemed like months later. And then Mr. Green never returned his call because it's been months. But he also spoke to law enforcement about that confusing search. But I'm like, wait. You called them? I'm going to need more information about that. I have a lot of questions. I'm sure they'll come up with Alessi on cross. And then we started getting into John O'Keefe's phone, his Waze location data. We have heard testimony generally about battery temperature, how ambient temperature can impact battery temperature. Anyone that plays Pokemon Go and weather understands how this works. Anyone that's tried to take pictures on vacation when it's hot outside knows how this works. We understand how battery temps work, but we have not heard what the data is from John O'Keefe's phone. We have seen the Waze data from John O'Keefe's phone, and then we have seen the location data with the different location accuracy circles and at what time periods those location accuracy circles were quite accurate and at what time those location accuracy circles were not as accurate. I'm interested to see if this expert will take the other data, the movement data from the phone, the battery data, and the location data and say, look, at this time period when the location circles got completely inaccurate, the phone battery temperature was this and the movement showed this. I'm hoping to see all of that data together, and we're not there yet. Will we see it? I don't know. But those are the questions in my mind as we take a break now. Knowing that I have more information than the jury does, the jury doesn't know who Mr. Green is yet, hasn't even heard the name. The jury has heard Jen McCabe's name. So I'm sure when they started talking about Jen McCabe's phone, the jury was like, we're always hearing one name in this trial. And you know what it is? Jen McCabe. Have we heard Jen McCabe's more than Karen Read's at this point? We might have, but the jury has heard this name come up a lot. I think it's very interesting that the prosecution has chosen to put this data in before you get to Jen McCabe. Explain the Google searches before Jen McCabe even comes in. Because if the jury's listening, they're like, okay, that's an explanation for the Google searches, and that seems to track with what we've heard. However, all they've heard about the Google search really at this point is in opening statements and then from Carrie. When Carrie Roberts testified about the Google search, it was very much on cross-examination where she was being asked about telling the grand jury, oh, so you heard Karen Read ask Jen McCabe to make these Google searches. That's what she told the grand jury. And then it comes to bear that that's not accurate. She didn't hear Karen Read ask Jen McCabe to Google anything. She saw Jen on her phone, and later Jen told her that that is what happened. But she saw Jen on her phone. And we went through that quite a lot with the cross-examination of Carrie about what she told the grand jury when asked what she heard Karen say. And she said she heard Karen ask Jen to make those Google searches. No, she didn't. She heard Jen tell her that that's what Karen said.
Did you have an opportunity to create a timeline, putting all of these different important pieces of data together so you could show them to the jury in chronological order?
I did, yes.
Would you share with us now your timeline and explain it for us?
Of course. So again, this combines all of the information from the previous slides, just showing it all within a timelined view. So at 18 minutes and 25 seconds, the device is unlocked using Face ID. We see the SMS application is in use. For around 11 seconds, a phone call is made from John to Jennifer McCabe. Phone call lasts 36 seconds, starting at 18 minutes and 47 seconds. That call ends at 19 minutes and 23 seconds, and the mobile phone application is closed at 19 minutes and 24 seconds. At 19 minutes and 29 seconds, the Waze application is loaded on screen. And at 20 minutes and 49 seconds, which is what this location on the side relates to, we see an incoming message from Brian Higgins saying, "You coming here?" At 22 minutes and 14 seconds, this is the start of the 3 flight climb events as the device is driving along Oakdale Road, I believe that one is. At 24 minutes and 26 seconds is when the Waze application is closed and the device is locked via the lock button at 24 minutes and 28 seconds. At 24 minutes and 37 seconds, the three flight climb events comes to an end. And at 24 minutes and 38 seconds is the first record that shows a speed of 0 meters per second. At 24 minutes and 59 seconds, the device is unlocked using Face ID, and the message, "You coming here," is read at 25 minutes and 8 seconds after midnight. At 25 minutes and 9 seconds after midnight, the device is locked using the lock button. At 27 minutes and 33 seconds after midnight, a text message is received from Jen McCabe saying, "Here." At 27 minutes and 45 seconds after midnight, the device is unlocked using Face ID, and the here message that was just received is read at 27 minutes and 48 seconds. At 27 minutes and 50 seconds, the lock button is pressed by the user, causing the device to lock. At 29 minutes and 37 seconds, we start to get some Doppler checks, and at 29 minutes and 42 seconds, the pocket state cleared event is written. At 29 minutes and 44 seconds, there's an incoming call from Jen McCabe. This is answered and lasts for 7 seconds, ending at 29 minutes and 51 seconds. At 29 minutes and 52 seconds, the device is unlocked, and a second later, the lock button is pressed, causing the device to lock again. 31 minutes and 47 seconds after midnight, a message is received, again from Jennifer McCabe, saying, "Pull behind me." And at 31 minutes and 52 seconds, the Doppler check records a pocket state. At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. And at 32 minutes and 3 seconds, there's a pocket state cleared event. At 32 minutes and 4 seconds, the device unlocks with Face ID. And again, I'll point out that makes perfect sense if the Doppler state clears, because it's no longer within a pocket, and then it unlocks a second later. That makes sense with the logic that's been identified. At 32 minutes and 5 seconds, messages applications on screen, and the message "pull behind me" is read. 32 minutes and 9 seconds, the messages application is closed, and the device is locked for the last time. At 32 minutes and 16 seconds, the 36-step health event is ending. At 33 minutes and 14 seconds, we have the first of the 26,500 Doppler state records that all record pocket state. This is followed by several phone calls at 33 minutes and 35 seconds, 34 minutes and 9 seconds, 34 minutes and 38 seconds, 35 minutes and 9 seconds, 35 minutes and 35 seconds, and 36 minutes and 9 seconds. All calls from Karen. Call were all unanswered, and all resulted in pocket state being detected by Doppler. At 36 minutes and 9 seconds, and again at 36 minutes and 40 seconds, 2 more phone calls received from Karen, again showing unanswered calls and resulting in pocket state being recorded by Doppler function. 37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. And at 37 minutes and 8 seconds, a further phone call, again unanswered, again resulting in a pocket state recorded by Doppler. 37 minutes and 31 seconds, a 3-second voicemail received from Karen. And at 38 minutes and 21 seconds, another incoming call. And at 38 minutes and 26 seconds, another incoming call, both unanswered, both resulting in Doppler pocket state being detected by Doppler. And I've also shown some of the locations that were recorded at around this time by the device. 40 minutes and 31 seconds, a message received from Jennifer McCabe saying hello. This is the first iMessage or SMS message received by the device, which is unread. This is followed up 2 minutes later, 42 minutes and 9 seconds, by another message from Jennifer McCabe saying, "Where are you?" And at 42 minutes and 35 seconds, there's a 40-second voicemail received from Karen. 43 minutes past midnight, the battery temperature has now dropped to 66 degrees Fahrenheit. At 45 minutes and 53 seconds, another incoming message from Jennifer McCabe saying hello. And again, we can see location data at 53 minutes and 7 seconds, placing the device on the front yard somewhere kind of around the flagpole area. 55 minutes and 31 seconds, a message received from Karen stating, "I'm going home." 55 minutes and 50 seconds, a follow-up message saying, see you later. Another location data, this is the location that's shown bottom left. And at 2 minutes past 1 a.m., another message from Karen saying, your kids are cooking alone.
There are two communications, one from Jennifer McCabe and one from Brian Higgins, correct?
Correct.
Now let's go to the next deck 80, please, Mr. Wolk. This is 122745, device unlock with Face ID, correct?
Correct.
And then right under that is 122748. It says read message, which it says here. And is it correct that that is the message that was sent by Jennifer McCabe?
Correct. I'd just like to point out it says read message, not read message.
Read message, thank you. And that, the fact that Jen McCabe sent that message and that it was read was not indicated in your timeline at this point, correct?
Sorry, repeat that question?
Yes. You did not, it does not appear in that timeline that you've drafted that that message that was read was from Jennifer McCabe, is
Correct.
it?
Correct.
Next entry, 2750, device locked with lock button. Next entry down that, 2937, Doppler pocket state. And I want to be clear. Does Doppler pocket state mean that someone takes an iPhone? Because up above there's read messages we went through on 2748. So if somebody reads the message and then it goes at 2937 into Doppler pocket state, does that mean someone has, for example, put it in their pocket?
No.
What does it mean that's a pocket state?
So the only times that I was able to cause a pocket state to be recorded is when the camera was blocked and when the device received a phone call or was picked up in a particular way so that the device thinks that you're about to try to use it. If the camera is not blocked from the outset, then nothing's recorded at all. And in order to get the pocket state cleared, the camera must be blocked to begin with. So again, you have to receive a phone call with it in your pocket and remove it in order to get a pocket state cleared.
Thank you, because that helped me, because that's exactly where I was going with the next question, which is pocket state cleared. What did you conclude from 2937 to 2942 that it was in pocket state and then pocket state cleared?
There was some activity on the device that caused the pocket state to be checked. The device was in a pocket state up until 2942, when whatever was obstructing the camera was removed.
Next entry is a call at 12:29:44. And that, you state, is an incoming call from Jen McCabe, so there you do indicate the name. And you say answered 7 seconds, correct?
Correct.
Is the phone at this time that there's an incoming call from Jen McCabe that is answered out in front of 34 Fairview?
Yes, it would be according to the location data.
Right. So now we have at 12:29:44, the phone's out in front of 34 Fairview. There's an incoming call from Jen McCabe. It's answered. 7 seconds is how long the duration of the call was. Is that correct?
Correct.
And then 12:29:51, incoming call ends, and that's end of that 7 second duration.
Correct.
So you've concluded that this was a call that was indeed answered by the user of the phone, correct?
Correct.
We're at the lunch break on day 5, and we just tiptoed into the cross-examination of the expert from Cellebrite, Ian Whiffin. So we are right at the beginning. At the end of that testimony, though, we did get a timeline that overlaid the information that we were looking for, the health data with steps and stair calculations, the temperature, the phone having incoming calls or texts, when calls were answered and texts were read, in addition to the data from Waze and the location data when it was shared on the timeline. So we saw Alessi starting to go through the timeline. And at the beginning of Cross, we did not see him challenging the timeline. We saw him, A, confirming certain points in time. I think those points are going to be incredibly relevant to the defense. And we see him pointing out those times, not challenging that they're not accurate, pointing out and highlighting them. We also saw him highlighting what is and is not on the timeline. Why is it here? Why did it get left out of the timeline? Alessi's not going to ask the why questions. This is Cross. You left that out of the timeline? Yes. And that is where we're at. Alessi was just going to start getting into a report written in March of this year by this witness when it was time for the lunch break, because we have a whole afternoon of Voir Dire with the ARCCA witnesses regarding discovery.
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. No. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
I don't think I can emphasize what a unusual situation this is in court. I don't think I've ever seen anything like this. It seems to me that there is a federal investigation looking into this investigation. They hire their own accident reconstruction experts, this expert and his business partners. And then in the discovery from the feds dump a bunch of discovery on the defense and the prosecution in this case. Within that discovery is a report from this company. And the defense reads the report and goes, oh shit, these accident reconstruction experts that we did not hire don't conceive of how the victim in this case was struck by a car. This information is out there. The prosecution has it. We have it. We need to bring this in at trial. But there's also a federal protective order. What do we do? That is the situation he is trying to elucidate for Brennan.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay. All right.
Objection, Your Honor.
No comments, please.
So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
Sustain.
Do you want to answer my question, or do you want me to move on?
Woo!
I think I answered your question.
I don't think you did, so I'll ask it one more time.
Objection, Your Honor.
All right, no comments, please.
Do you think that providing
Your Honor, he is ignoring you.
a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline,
Well,
whether I
that's not a
testified on
direct
behalf of the defense or behalf of the Commonwealth.
That's not a direct answer at all.
You don't want to answer my question?
Objection, Your Honor.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
He said
Going
it
to allow that.
would assist
You
the
were making suggestions to help the defense,
understanding.
weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
Yep.
So there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
Yes.
I don't believe so, no, sir.
And then
I
when you
see
wrote,
it differently. Yes. I was trying to help the jury understand the testimony. So it would be clearer if you asked me about these things. Yes, I was trying to assist in the testimony coming in a clear fashion. And that is what he keeps saying. And then Brennan's like, you're trying to assist the defense. And he's like, I'm not trying to assist the defense. I'm trying to make my testimony clear. Brennan's putting a value judgment on it because he wants these witnesses to come across as biased. He's saying, no, I just want the testimony to come in smoothly. And Brennan's putting a value judgment on it, and he is not going to accede to that value judgment. And that's why we're still here. At the end of the day, the jury's not going to hear 98% of this. And I don't know if it changes everything
have
or
a
anything.
feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides. You're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
Oh my God. The court has admonished him multiple times to stop it with the comments. The comments have not been stopped.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone of the argumentation.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Your Honor.
Correct. Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. Yeah. That's what I was trying to make sure that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it?
It wasn't a collaboration.
You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19.
I mean, maybe.
Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
Oh. And then, do you defer to the defense, not the jury, trying to give the full story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you, did you defer?
Answer the question first.
Did you defer?
Isn't it a voir dire? Isn't the purpose of a voir dire is to get answers to questions, not a cross-examination? It's a voir dire, not a game of gotcha. Okay.
The defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on. Next question, Mr. Brennan, then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes.
Yep.
Allow me to explain.
Nope. He's probably not gonna.
For one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions. 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
He told the defense.
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to...
Did you inform the court about your misrepresentation?
He informed the defense.
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not. Correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
Well, before you testified, did you get a chance to meet anybody from the defense?
Just when I came to court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approached me.
So you spent some time with them?
Certainly, yes.
Okay.
So at the end of the voir dire day, the court ran over a little bit to get this done. They barely had any time with the second witness because Special Prosecutor Brennan brought all of the special snark at Dr. Wolf, just all of it, about whether or not there was an email sent or whether it was a conversation, what the communications were. If, ARCCA is like rooting for the defense, aren't you trying to help the defense? Aren't you doing this to help the defense? What do you mean you didn't communicate with the defense? And round and round and round with Brennan yelling at the witness before we then had Alessi's questioning, which again went around and around, covering a lot of the same ground. I think it's clear that Alessi doesn't necessarily trust the court to hear what he's saying. And that's the sense I get from his, and that's purely my speculation. That is the sense I get from his style of questioning, where he breaks things down and then asks them in multiple different ways to make sure that it's clear that there's nothing nefarious. Where I think Brennan started making better points to support the argument that he is going to make is when he got into how long it takes. Oh, so you need the raw data because you want to be able to check against the conclusions. Oh, so you need the raw data, the report, the photos, the videos, and then it would take you more than a month to do that information. This is where Brennan, I think, is trying to get to, keeping out ARCCA's new information. But it sounds like from ARCCA that they have been brought into the case this time not to cover the report that they originally did and not to give those opinions, but to respond to and rebut the Commonwealth's expert instead of proactively give their own research. So what they were saying is that they took in the new expert from the Commonwealth and are going to say, this is why we don't come to the same conclusion. This is us rebutting that conclusion. So I think where Brennan is going to go with that is saying, but Your Honor, if they're giving us this information so late, we need time to then have it double checked with our expert. And I imagine where the defense is going to go with that is, but this is rebuttal. We're not bringing them to do anything other than to rebut your expert. So there is going to be more argument, I imagine, between the defense and the Commonwealth over the scope of ARCCA's testimony. Remember, the court already said she was allowing ARCCA in, but that she wanted to have the voir dire and would determine the scope of their testimony, and limited the defense from being allowed to discuss ARCCA during their opening statement. We've also seen the prosecution say that they would need more time. They would need more time to address the ARCCA stuff. We only got to the voir dire today. We did not get to the argument about it. I wonder when we will get to the argument about it, because it's going to come up. I would imagine we'll see probably another motion filed by the Commonwealth regarding this, saying ARCCA can't testify, we don't have enough time. I think that's the direction they're going to go in. And the defense saying, we didn't even get the raw data from the Commonwealth until this time. But we did see the Commonwealth bring up that ARCCA wasn't under contract with the feds past June of 2024. And we saw the Commonwealth bring up, they say that they turned over all the raw data to the defense well before ARCCA got it. Though during the hearing, with the amount of yelling from Brennan, it was unclear to me exactly when that information got turned over. But we know that Brennan's argument on that is going to be they could have picked a different expert. ARCCA was done with the feds in June. The defense could have picked a different expert. They knew that we had retained our new expert, and they waited and waited and waited. And ARCCA didn't even reach out to the feds to see if they could work with the defense in this trial until March. The trial was originally set for January. What would they have done then? So when we see argument from the Commonwealth, it's going to be the argument that, well, the defense waited so long to give them this information so they wouldn't have to disclose it with us. One of the really solid points I think Alessi made during his questioning was that ARCCA was never questioned about any of their communications with the defense the first time they were voir dired. That voir dire didn't really have limitations to it. The court didn't say you can't ask discovery questions. It's only about the report. The court said at one point during the voir dire with Attorney Lally in the first trial, this is your time. You can ask them what you want. Lally did not ask those questions. And it was pointed out, I think, very effectively by Alessi during this questioning. You weren't asked about communication with the defense. You weren't asked about if you expected to get paid. You weren't asked about what case number you were billing under. You weren't asked any of that. So is that on the defense or is that not on the defense? Is that on Lally for not asking those questions during the first voir dire? Oral argument on this is going to be fiery. We haven't gotten there yet. I'm interested to see what the new expert for the Commonwealth has to say. I'm interested to see how the defense brings up, well, the pirouettes and the rest of it. So we are not done with the ARCCA question at the end of the day today, nor are we done with the first witness that was on the stand today. We are just left unsatisfied. Are there any answers at the end of today? No. I don't think there's any answers at the end of today. But we do know that the feds kept a close eye on the first trial, which was news to me, and were having conversations with the ARCCA experts about the first trial. Brennan represented that there was a sequestration order that seems to have covered experts, which again is an unusual situation. Generally, experts can watch the testimony of other experts. But again, they were never asked about that by Adam Lally, but it seems that the feds were watching the first trial very closely and communicating with ARCCA about it. And at the end of all of it, we got to Dr. Rentschler having lunch with, it seems, Karen Read, her family, possibly the defense team, where he said, I stood in a corner and was waiting for my ride to the airport and they said, have lunch. And I stood in a corner and had lunch after my testimony. Is that going to matter when these experts testify all that much? I don't know, because they've been retained by the defense. So is the jury going to be like, oh my God, I'm so shocked that y'all had a lunch together once and the defense hired you? I don't know if that's going to be shocking to anyone. We will see when we get to that testimony, if it even comes up. But the court cutting off Brennan's questioning was like, we're getting this done today. I think Brennan wasted a lot of time on stuff that didn't really help him very much, and then lost a lot of time in the testimony that might have been more helpful for him. But again, we have to wait to see argument. And we have to see what the court rules. I'm curious. And here we are. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.